Can you hear us okay?
Yeah, this way.
Okay, you
Hers
can.
is this way. That's okay, she's starting.
All right. So just as a quick introduction, we're going to be talking about ethics, good land grant, and Acequia governance. I've got my, can I say co-counsel?
Sure.
David here to assist. Before I worked for the Utton Center, I did represent a political subdivision of the state of New Mexico, and I do sit on a board as an elected official right now, so a lot of these laws that I'm going to talk about apply to me as well. So, you know, I have it near and dear where I have my book handy and tabbed, and I also have these resources available if you do want it emailed as well. I do want to say that my husband, my last name is Russo Baca. Baca is my married name. My husband's family, on his grandmother's side, Juan Luis Carrillo was an original heir to the Acequia de la Joya land grant. So it's an interesting topic for sure. We're going to go ahead and dive right in.
And I'll say something just to start out, and that is, for those of you who are interested in helping or working with land grants and acequias, it's a very rewarding thing to do. We've talked about a lot of very dramatic things and dramatic cases, but there are hundreds and hundreds of everyday decisions that acequias and land grants need to make, and they need to make them, they need for them to just be made once and done procedurally correct and in compliance with state law, so that no one can challenge it, and so that they can make their decision, feel confident that they have made it correctly, procedurally, and that they can't be challenged and move on to the next thing. And that is such a service to acequias to be able to assist acequias and land grants at doing that, and that's what we're talking about. These are technical things in the law that the leaders wouldn't necessarily know. You know, how would they be expected to have memorized all these things in the law? But it would be your job as an advocate to help them do that.
Thank you, David. Yes, and it's such an important thing as a political subdivision of the state or as a government entity, as elected officials, that we make sure that guiding these elected officials that we have an open government, right? So citizens should have the ability to also be able to enforce the law in a way by knowing these laws, right? So when you elect a board or a commission, they are representing you, and so to know that they need to comply with these Open Meetings Act or IPRA or the Government Conduct Act, it keeps us honest, and it also gives some more notoriety to these entities, right? Previously, we had a lot of issues where it's like, oh, land grant or an acequia, no big deal, but no, this is, a political subdivision of the state, right? These are elected officials, this is a government entity, and they have to be taken seriously, so it's really important. I'm going to go over the roadmap, what we're going to discuss today. Arturo said that, there's a lot of statutes that affect acequias and land grants as well. And we're just going to go over, the view from 10,000 feet, if you will. So we're going to be talking about the State Ethics Commission. First, the Open Meetings Act, the Government Conduct Act, IPRA, the Information and Public Records Act, the Audit and Reporting Requirements, the Procurement Code, and per diem and mileage. Okay, just making sure. So the State Ethics Commission really is an independent state agency that promotes integrity of state government. And so the commission has jurisdiction to enforce the civil compliance provisions of 8 statutes and 1 constitutional provision for public officials, employees that are public, notaries, candidates, and persons subject to the Campaign Reporting Act. So the 8 statutes are the Campaign Reporting Act, Financial Disclosure Act, the Gift Act, Lobbyist Regulation Act, Voter Action Act, Governmental Conduct Act, the Procurement Code, the State Ethics Commission Act, and Article 9, Section 14 of the New Mexico Constitution. However, people that are not subject to the Commission's jurisdiction are local officials and employees. And the jurisdiction of the administration is limited. For example, it can't hear complaints against local elected officials or public employees such as county commissioners or municipal employees. However, even though it doesn't have the authority over some of the smaller employees, the commission can pursue civil lawsuits in state court against local officials and employees to remedy violations of the Government Conduct Act and the Procurement Code. So that's why I wanted to make sure I included. A lot of people, don't realize that there is a state ethics commission, but it's important too that they're actually there also not to just enforce the law, but to help as well. So, if there was a question, you could actually ask the State Ethics Commission does this apply to me? And, before there's ever an issue, to reach out to them. And I think that's really important, is that there are these resources available. And the Commission does lack jurisdiction over conduct that occurred before July 1st, 2019, so it's relatively new as well. So it won't go retroactive, but will, from now on. Okay. I'm going to be talking about the Open Meetings Act next. So there isn't, as pictured here, there's the New Mexico Open Meetings Act Compliance Guide. And that's provided by the New Mexico Attorney General's Office. This is one of the resources that I was talking about that is available online, or we can send it to you via email. And I have it printed out as well. So the Open Meetings Act, again, is the state law that provides statutory guidelines for conducting public meetings. Land grants under 49-1-12 state that all meetings of the Board of Trustees shall be held in accordance with the Open Meetings Act. Executive session shall not be held except in accordance with the Open Meetings Act. All heirs of the land grant recipients shall have the right to be present at all times when the board is in session and to be heard on all matters in which they are interested. Same thing for community Acequias that are political subdivisions of the state are therefore also required to comply with the Open Meetings Act. All meetings of a quorum, which is a majority of the members of any board, commission, administrative adjudicator body, or other policy-making body of any state agency, and any agency or authority of any county, municipality, district, or any political subdivision, if they're discussing personnel, policy, rules, regulations, or ordinance, or any public business, for the purpose of taking any action within the authority of or the delegated authority of any board, commission, policy-making body, are declared to public meetings have to be open to the public at all times, except as otherwise stated in the Open Meetings Act. And so we're going to get into a little bit about what an executive session or a closed session is, but you do have to give the public reasonable notice. The elected body shall determine at least annually in a public meeting what notice for a public meeting is reasonable when applied to that body. So depending on what the entity is, right, you might not have the same public notice for each entity, right? You don't have to make sure that it's published in, say, the Albuquerque Journal if you're in Las Cruces, right? You would put it in the Las Cruces or so on and so forth. It has to be local to your entity. And then notices do have to be given though, right? You can't just put it on your public body and say, well, we're only going to post it in our land grant policy. If that's not a reasonable place to post it or people would be aware of it, that could then be said you didn't give the public enough notice. So keep that in mind. I don't know if you want to add anything.
I think once you go through this list, I will.
Okay.
Yeah, thanks.
So again, so in writing, and it can't just be word of mouth, right? You can't just say we're going to have this notice on such and such date. It has to be in writing and available to individuals. And it doesn't necessarily have to be in English either. It can be in the language that is most commonly used. So the meeting notices have to include an agenda, with specific items of the business to be discussed or transacted at the meeting, or information of how the public can obtain that agenda. So once you have the agenda with the list of specific items or business to be discussed, and the public can get a copy of that agenda, it's seen as posted, if you will. So once you actually have the meeting, if you have discussion that's outside of that agenda, you'd either have to amend your agenda at the meeting, but it really can't be outside. If you were going to discuss, payment of dues or something like that, and then you discuss something completely different, would that really feel like you've given the public enough notice? Probably not. And the whole point of this is, right, like David said, is so you're giving the public that opportunity to be heard and to hear. So, in that, if somebody's not able to attend the meeting, right, after you've done all this hard work of making it public, you do have to keep written minutes of all what occurred during the meeting. And so the meetings have to include, at a minimum, the date, time, and place of the meeting, which members were present, as well as who was absent, right? And then the substance of proposals considered, and any records of decision. So if there was a vote taken, it has to be in writing. And then all minutes are open to public inspection. However, if there's something that's discussed in closed section or executive session, such as things that attorney-client privilege, something that's threatened or pending litigation, in which the public body is or may become a participant, and meetings for the discussion of the purchase, acquisition, or disposal of real property or water rights by the public body. So those are all things that can happen in closed session, but if something was taken of, say, a vote per se, you would have to go outside of executive session and make that vote public, right? So you can't, you can discuss what you're going to vote in executive session, but you can't make that actual vote in that session. It has to be done in the public. So. Okay. I'm going to go over an Open Meetings Act example. So one of the things that when I discussed a quorum, right, and it has to be a majority of the elected body, right? So we have a specific rule called a rolling or walking quorum. A lot of times the board members are members of your community, right? You see them a lot. And that's fine, that's not an issue. The issue is if you're discussing business with each other. And so, let's see if this worked. Okay, so say for example we have a 5-member board of directors. There's an upcoming board business decision. The first board member calls the second board member to discuss this business decision that's going to be coming up on for a vote. Right there, do you think that's an issue? Maybe, maybe not. Probably not that big of a deal. It probably doesn't violate the Open Meetings Act at that point. The second board member then emails the third board member on the same topic as the first board member discussed. How many of you think that that's a violation? Most definitely, right? And if you notice, right, the first board member called the second one. The second board member then emailed the third one. It doesn't matter how you communicate with each other. It could be by like carrier pigeon or whatever. It doesn't matter, as long as you communicate.
So my question to you was the first communication between the two not a problem because it wasn't a quorum in the combined communications, but then once you added the third one in the combined communications, that became a quorum, and that's what the problem is? Is that what you're saying?
Correct, right, yeah. So you could discuss business, and even say, for example, if, say the third and fourth board member talked, and the first and second one talked, but they didn't necessarily know they talked to each other, that could get tricky, but it's probably not a violation of the Open Meetings Act if third and fourth board member don't talk to first and second board member. So it's one of those things where it's a little tricky, but it, in your mind, right, think of, would you want to be discussing business meetings outside of an open meeting? Probably not, but it does come up, right? And so that's why this Opens Meeting Act is, on the books. And you can attend events. Say if there was all the board members of the land grant that were here today, right, in this land grant that we're present at. That's fine. They're not discussing business for an upcoming board meeting. That's not an issue, right? So just to be very clear on that.
Right, all the board members could attend a training, for example, and that's not a violation.
Correct. Right. So, all right. So next we're going to talk about the Government Conduct Act.
So I'll jump in here, just with a couple of comments on the Open Meetings Act. So a lot of people in land grants and acequias think that the Open Meetings Act means transparency among your membership, and that's true. It does mean that, but it also means transparency to the public and to the press. So an open meeting not only means that your members know about it, but there's an opportunity for other members of the public or even the press to know about it and attend. That's what an open meeting is. It's not open to just your members. It's open to everyone out there. And so that's an important thing to remember. The other thing is that you mentioned minutes and what has to be in the minutes. So there's an interesting Acequia case in which someone complained, this is in Parkview Community Ditch, this is up in Tierra Maria, and someone complained because the minutes didn't say how each member voted in an election of the officers. So they called a meeting, had a vote in which it was every 2 years they vote on officers, and the minutes didn't reflect who voted for who. And the question is that a violation of the Open Meetings Act? Because the Open Meetings Act does seem to suggest that you have to record the votes. How do you think the court decided on that? Enrique, you can't say. They said it was not a violation of the Open Meetings Act, and this is why. They said the idea of the Open Meetings Act is to record votes to hold accountable elected officials. So if the commission was holding a vote, the Acequia Commission was holding a vote, that vote would have to be recorded who voted which way. But this was an election, and it's you don't have to hold the members accountable for who they're electing as their officers. Therefore, a vote of the membership does not have to be recorded in the minutes, and failure to do that is not a violation of the Open Meetings Act. So a couple years later, the same person who complained about that complained because the Acequia held a meeting in Spanish, and an English-speaking person complained during the meeting and was offered a chance to have a person translate the meeting and refused, and then after the meeting sued the Acequia for holding the meeting in Spanish. And so with the law clinic, I worked with a bunch of law clinic students and a number of other attorneys on that case, because there's New Mexico constitutional provisions that have to do with us being a bilingual state and what that means. And anyways, I'm getting off the subject, but it was the same ditch that the guy complained about the minutes not being correct. Same person complained about it being held in Spanish. And what happened, it went to the Court of Appeals. We won in the district, or not we, but the other people, we were amicus. The trial attorney won in the district court for the Acequia, and it went to the Court of Appeals. And the Court of Appeals actually kind of, I don't know if it dodged is the right issue, but did not analyze the whole issue of speaking Spanish, entities being able to speak Spanish in meetings. They instead found that the whole appeal was done incorrectly, that this is a case that had gone up to the Court of Appeals and back down, and it was not until it went back down to the trial court that they first raised the issue of speaking Spanish. And so it went back up to the Court of Appeals. The Court of Appeals said, you raised it too late. You should have raised it in the first place. And anyways, that's what happened there. And the last thing I'll say is that the Attorney General Compliance Guide for Open Meetings Act is excellent. I think it's really user-friendly. It gives examples it gives the statute, but then it also gives tons of examples of all these different things like rolling quorum and things that we're talking about. And it's a good thing to get if you're going to be assisting governmental entities on Open Meetings Act. They have a separate guide for Inspection of Public Records Act. You're going to say that too, right?
I was going to say too that they are willing to, they also do trainings as well. So the Attorney General's office is willing to do trainings with individuals, you know, if there's something, or you can even ask them for an opinion as well. So, great, thank you. So the next thing we're going to talk about is the Government Conduct Act. So, something very interesting, in 2011, the law's coverage was expanded to officers and employees of all political subdivisions of the state and their agencies. So, really what the Government Conduct Act specifically for if contracts with current or former public employees and families is covered in Section 7 and 8. So even if you're no longer a government employee or a public employee, it still can apply to you even after you've left. Additionally, sales to supervised employees or regulated entities is another section, and then there's also legislature and family conflicts of interest, as well as contract negotiations. And we can get a little bit into that further. And so again, state agency means any branch, agency, instrumentality, or institution of the state. As well as anywhere in the guide, employee, officer, or official can be interchanged. So here's some examples. So example 1, an elected member of a local land grant receives no salary, but is eligible for per diem and mileage reimbursement. This member never asks for reimbursement of his travel expenses. So, do you think this person is subject to the Government Conduct Act because he doesn't receive any funds? They are still. It doesn't actually matter if you never receive any funding, as long as you are eligible to receive that, even if you never can. Another example. So an employee of a political subdivision of the state is funded totally with federal grants. What do y'all think? Does it apply to them? They only receive federal grants, but they're an employee of a political subdivision of the state. Okay.
So let me ask a question. What's an example of when you say this person comes under the Government Conduct Act of something that would regulate them? In other words, would it be something like if I have to recuse myself because something is coming before me as a decision maker that involves a close family member? Is that an example of?
That's exactly right. So one of the things where Government Conduct Act, just as an example of that, is perfect, right? So I'm going to, I know that there's something that's going to happen on the board that I sit on, and I realize though that that's going to directly benefit my employer, right? So it's going to directly benefit UNM. I have to then recuse myself from that decision because it would directly benefit something that benefits me then. And forth.
Got it. So these questions about whether I come under the act or not determine whether technically I have to recuse myself or not.
Right, and that's just, one example. So, again, and this is like a interesting funding issue, right? Because even if the funds, it's very tricky, right? And that's why it's so important to have these good attorneys, right, that are able to walk these elected officials through these decisions. So, yes, regardless of funding source, as long as you are a political subdivision of the state, you still fall under the Government Conduct Act. Right? However, if, say it's a nonprofit agency and they receive all of their, major portion of their funds through the state, right? So this is almost a reverse of the and the director of the agency pressures an employee to support a certain political candidate. Do you think that this is a violation then because it's state funds? While the director's actions would be a violation of the Government Conduct Act in a state or local government agency, the managers of the nonprofit are not subject to the Government Conduct Act in exercising their supervision of employees, even though their nonprofit agency receives public money. So it's really centered on if you're a government employee. So it's kind of interesting, right? Here it's almost a double standard in this case. Go ahead. Somebody had. I'd rather just answer the questions because I think we're going to run out of time.
I don't understand what's the point of the Government Conduct Act if you have an ethics act. It seems to me like they're dealing with the same things. Or what's the point of having the ethics rules if the Government Conduct Act covers the same kind of behaviors?
So do you mean the ethics? So the Ethics Commission is a separate commission, right, that is to help interpret the ethics that government employees have to follow, whereas the Government Conduct Act is the actual laws that are followed.
So correct me if I'm wrong, because I'm not entirely familiar with all of these things myself. Is the ethics thing is not a law, it's a commission, it's a group. Whereas the Government Conduct Act is the law that sets out what is appropriate conduct, and the Ethics Commission helps you understand that, or I guess prosecutes you if you violate it. Is that right?
Yeah.
Okay.
Yeah. So, you know, and it's interesting, right? Because we have a lot of this government oversight, right? And it's maybe because we have in the past had some unethical elected officials at higher levels than at land grants and Acequia associations. And, you know, it also applies to, you know, say not just the elected officials, right? But it could also be seen as applying to like the attorneys, right? If you're employed through the an Acequia association, you know, through an Acequia or through a land grant, right, then you have that legal obligation, right? It's ethics not just for the elected officials, but, right, the employees of them. So depending on how the contract works, if you will. So, you know, it might be a good thing that there is more ethics regulations than not. Because it seems like in the past, from these last 2 days of hearing all these unethical issues that attorneys have done in the past, that maybe it's a good thing that there is more, you know, regulation at this point.
Andrea has a question.
So for an attorney representing the Acequia, it should be attorney-client privilege communication, though, to be able to have a discussion with, say, the board, that you don't have to hold an open meeting to do that, correct? I mean, I don't understand. I've never heard any requirement to, if you're the attorney, to actually hold, you know, post notice and publish all of that for a meeting with your client. Am I correct, or is that wrong?
That would be really interesting for something that specific to talk to the Attorney General's office about. I mean, it's something that, right, if it's, to me, you know, in dealing with Open Meeting Act issues, right, if you're discussing with an entire board and the whole board is there and you're discussing, that's a quorum, right? So it would be prudent, I would say, to have a published meeting, even if it's a special meeting and it goes straight into executive session, and then you discuss that with your client. Otherwise, you have the issue of possibly violating the Open Meetings Act because you have all the board, a majority of the board members in a quorum. But if it was not a majority and it's not a quorum, then an attorney could discuss that without violating the Open Meetings Act.
I agree that it's prudent to do that in that case. Now, that's distinct from you, like sending out a letter reporting on the status of the case to all of the members.
Well, that's what I'm asking, because, you know, if I say, hey, we filed this motion, and so far this is where we're at in the case, and this is what I'm recommending to you as a board, you send it to the whole board, is that violating the rolling quorum requirement, the rolling quorum requirement?
I would say that the state engineer would, the Attorney General, The Attorney General, I'm sure, would say that you informing them of their options is one thing, and them making a decision on the basis of your letter is another thing, that the decision would have to be made in an open meeting. And again, the open meeting, you can actually advertise a meeting, in the proper way that notice is given for your type of entity as a closed meeting in its entirety. So you can say, because of this reason, because it's pending litigation involving the land grant or involving the Acequia, this will be a closed meeting. It will be held at such and such a time, such and such a place. You give all that information, but it's not going to be open to the public or the press, because the only thing that's on the agenda is something that you're allowed to close a meeting for. And minutes have to be kept of any decision that's made. And again, you can't make a decision in executive session. You have to actually make the vote in an open session that's open to the public and the members and the press, kind of thing. So that's how my understanding. Enrique or Mary or anyone, do you want to add anything to that?
No, I agree with what David's saying. I mean, and just to also, the Open Meetings Act talks about the exemptions, not exemptions, but when you don't have to call a meeting, and things related to the attorney-client privilege are there, but just as David and Stephanie are pointing out, it's prudent to think about, number one, will there be a decision made as a result of your communication to the local subdivision, and if so, you're going to want to do that in an executive session. Not make the decision, but have that discussion in executive session, so there's not a problem later and someone tries to undermine whatever decision came out of it.
But again, you sending a letter out saying this is the status of the case and we're facing several options and these are the options and these are pros and cons, that letter in and of itself is not a violation of the Open Meetings Act if it goes to every single member of it. It's just what happens after that.
I guess what I would be confused about is like I send out a draft complaint, to my clients, and I say, review the facts and tell me if there's anything I need to fix in there. They get that, a review to me. Does that create a potential violation? I don't think it does, but that's where because they are technically making a decision about whether I'm sending out is correct or not. I mean, so you're getting really technical there, and it's very, I guess it makes me a little nervous because I want to be open with my communication with my clients and inform them of everything that's going on in the case and where we're at and strategies that could be applied this way or that. And I think that this could be, the way that it's interpreted could stymie that process in terms of open communication with the client.
Mary and Connie, do you mind if we ask you about your experiences with that?
I think you can communicate with them, by letter or even an email, and it requires a decision by the entire board. I think then they call a meeting so that they can put it on the agenda and, say it's going to be this, and say they're going to executive session to discuss, litigation matter. They don't have to go to that. And then, like you say, if there's a decision made, they have to come up with a meeting and tell the public.
Right.
But it's very tricky.
The example that she's giving is kind of tricky, Mary, because she's saying, I just wanted to get feedback on something that I drafted.
I'll make a comment on that though too, is it's not the board members discussing it. It's individual board members then say discussing it back to you. That's, I think, the big difference
Well,
with
yeah,
it.
but it's the rolling quorum thing that I'm concerned about because
But they're not
I have
as,
5 board members and they all give me feedback and I incorporate it into.
I think
And
that's,
I'm going to recognize Jesus because I think he actually has advised many political
I was
subdivisions.
a Sunday County attorney for 25 years. Well, I dealt with the Open Meetings Act day in and day out. You can write all you want to the 5 county commissioners or 8 city councilmen and the mayor and tell them everything you're doing. There's nothing wrong with that. And keep them informed. They even appreciate that. But you can also listen a decision from them as to what you should do. If they did that to you individually, that is a rolling quorum, and that's an absolute violation of the Open Meetings Act. But not to worry, there is one time that a public body does not ultimate decision in public. We all know that you can meet in executive closed session for a multitude of reasons, but you've got to come back out and make the decision in public, except in one area. And one area alone. There's 2 cases in New Mexico that allow this. When it comes to litigation, handling of threatened litigation involving the attorney-client privilege, our Court of Appeals and the most recent case of the Supreme Court says you do not have to make that decision in public. You can keep it within your breast. Why? It's very obvious even to a layperson. You can't discuss strategy, legal strategy and tactics and say we're going to file or seek a restraining order tomorrow in public. My God, that's crazy. So the courts have appreciated that. And so you don't have to make those decisions in public.
Thank you. Thank you for the clarification. That's
the against the Luna County Board of County Commissioners that allows that. I think it's costly versus Luna County.
Thank you for that clarification.
Sorry.
And thank you so much for the questions. And we only had an hour, and it was kind of a 10,000 feet view on these issues. More so, it's just to make sure that you're aware of these for you as an attorney and you as elected officials. Okay, so I'm going to go over the Inspection of Public Records Act. So IPRA is a New Mexico state law that provides the public and media access to public information. The law requires open access to almost all public records in state and local government, with few exceptions. Under IPRA, the public has the right to take legal action if they are denied access to public records. And this is an important mechanism to empower the public. And there is also an IPRA guide as well. So,
a very good one.
does it apply to land grants and acequias? So, shortly, yes. A public body includes political subdivisions of the state. So, community acequias are political subdivisions of the state and must therefore comply. Land grants that operate as political subdivisions of the state, as well as the board of trustees of the land grant. And as David mentioned in the very beginning, compliance with IPRA is important in order to avoid legal challenges. What records do you have to provide? So public records means all documents, papers, letters, books, maps, tapes, etc., regardless of physical form or characteristic. So if they're used, created, received, maintained, or held by or on behalf of any public body and relate to the public business, whether or not the records are required by law to be created or maintained. There are some exceptions to the rule, and this isn't a comprehensive list, it's just to give you an example. Say a personal medical record of an employee, a sick note, right? You don't necessarily have to provide that. And if there is something that is provided, you can, protect that personal identifier information. So you do have a duty to redact. If there is something that's public, say it was discussed in an open meeting and there's minutes, but the minutes don't have to be public. Say if you can redact a specific thing, say if it's like a social security number in there, right? So that personal identifying information can be redacted even if it's a public document. So, and there are other specific limitations as provided by IPRA. Again, there is a really handy guide as well as how to comply with IPRA. And you can't quite see it too well here, but there's an example of a model public notice procedure for requesting an inspection, and then on the other side is an example of how to answer. Now, just because you do have to provide a public notice, say if it's overly cumbersome or it's extremely expensive to provide that, you do have a time limit in which you have to comply. and you do have to provide it, but you can charge, a reasonable fee. Say if they're asking for, 10,000 documents or something like that, you can request that the individual who's requesting the documents pay, for the paper essentially to produce that. So there are limitations. It's not just that you have to just say, yeah, you can have this and here you go. And it can be up to you. It's better if it is requested through IPRA, at least in my opinion. That way you have a track record of what has been provided and to who, as well as requesting, having that say in your bylaws even of if an IPRA request comes, here's the process and here's the custodian of who handles all of these records. And right, so it doesn't get lost and then you don't get into the issue of having then a legal claim against you because no one ever responded because someone said, yeah, I'm going to do it, and then it never happened. So, I don't know if David's encountered that.
So the only thing I would add is some people might be saying, this sounds like the Freedom of Information Act, and it is kind of like that. The Freedom of Information Act is federal law, and so the state equivalent of the Federal Freedom of Information Act is the State Inspection of Public Records Act, but it's very similar. Hang on just a second, I'm just going to say a couple things and then I'll call on you in just a second. The other thing that's important is that someone making an IPRA request can't demand that you compile a new document that doesn't exist already. So they can ask for lots of things. They can say, well, and the other part of that is if you don't actually have something that they ask for, then there's nothing to provide. You don't have it. You only have to provide the documents that exist that fit the description of what they want, and if they want something that doesn't exist, you simply inform them of that. But going back to what I was saying a minute ago, if they ask for, say, provide me with a list that includes, this, and this, you don't have to create that list. That's not what IPRA requires you to do. Oh, yeah, I'm sorry, yeah.
Once you get an IPRA request and you respond to them and you say, hey, you can come and review our records on these set dates, how much time do you have to give them to actually do that?
Okay, who remembers the time intervals? Go ahead, speak loud.
Well, so I think I'm going to answer probably not the question you're asking, we can talk about it. So, first of all, the request has to be in writing, right? So the deadlines aren't triggered until a written request is in writing. The political subdivision, the custodian, has to respond within 3 days. It doesn't mean that they have to provide inspection within 3 days. They just need to respond. So they need to respond within three business days. Okay, this is where it gets tricky because we're also going to talk about calendar days. So 3 business days to respond. If you get the request on a Friday, you don't have to respond until I guess the Tuesday of the following week to say either you've got the documents ready for your inspection or we need additional time. But you can't go past 15 days unless there's some exceptions. It's overly burdensome. It's not clear what they're asking for. You can try to get that clarification. But if it's pretty clear what they're asking for, you've got to allow inspection within 15 days. It doesn't mean you've got to make the copies within 15 days. It just means allowing inspection. And then you can, start thinking about, well, you want to charge up to $1. You can do more than $1, and you can't pay for the time it takes you to make those copies or to allow inspection, to make those copies. So there's some limitations.
$1 per page, right?
$1 per page, yeah.
So after that has been completed, they still haven't come.
Right.
How long do I have to keep it on there for them?
Yeah.
Forever, or does
Well, that's a good question. I don't know the answer to it. My thinking is that you've complied with the law. And by having provided in writing a response within the 15 days, you said they're ready for you to come view. I wouldn't necessarily in your letter say something like, let's talk, respond to them and say, let's talk about what date will work for you. I would just say these records are ready for you to inspect, but they certainly can, reach out to you and try to arrange a date. And if they don't, that's on them, but you comply with the law at that point.
I don't have to worry about it, because they're not responding, so I figure I did everything I had to do.
Yeah, that was my opinion. There's other attorneys in the room that think
I think we write a letter that says that you haven't come to inspect the records within so much time, and we're deeming that you no longer are requesting those records, but feel free to renew your request. If you want a later date, something like that.
And the Attorney General's office, if this was something where you wanted guidance on it, I mean, that's specifically where they would be able to help you with that. You know, I've complied, do I need to do anything else? I mean, I think that would be the best, course of action too. We're getting really close on time. There's no way that I'm going to get through this entire presentation, and I don't think we necessarily need to, because I think we've had a lot of really great questions, especially, we'll talk about, we'll just go through some IPRA examples, just for fun.
You guys have a little more than 10 minutes.
Okay. So a resident sues public body X before the court issues its decision. The parties agree to settle the case. They enter into a settlement agreement in which public body X agrees to pay the plaintiff a specified amount in damages. The settlement agreement included a provision making the settlement terms confidential. The court enters an order dismissing the case. The order does not incorporate the settlement agreement. Soon afterwards, the treasurer of public body X signs a voucher for the amount of the settlement payable to the plaintiff in the lawsuit. So, here's the IPRA request. An interested citizen makes a request for copies of certain vouchers, including the voucher for the settlement amount. The town provides copies of all vouchers requested, except the one issued in connection with the settlement. The reason that they deny access to the voucher is denied on the basis that the settlement amount is confidential under the terms of the settlement agreement. Do we think that this is following IPRA properly or not following IPRA properly?
Generally, confidential agreements, settlement agreements for a public entity are against the public interest, so the agency shouldn't be entering into confidential settlement.
You would think that. You can't actually withhold that voucher because unless it's protected by law in some other specific way, any information relating to your public body's expenditures has to be public. And I gave this example because this is I sit on a board that this happened to specifically. So you have to make any vouchers that you expend money to, and you're a public entity, even if it was part of a confidential settlement, you can't withhold that information. You can withhold everything else about the settlement except for that voucher.
So you can't get complained for having violated the settlement agreement if you provide the voucher, but not anything else about the agreement.
Correct, right? Yeah, I mean, even if it's just a check and that's it. So,
I think what I was trying to say is that settlement agreements for public agencies should not be confidential. For agencies should not be entering into a confidential settlement agreement because the courts have said that that is against the public interest.
yes. Oh, I see what you mean.
Because the public has the right to know how its government is being conducted and having the public know if it's a confidential settlement agreement. Which is why I don't understand why there's all these non-disclosure agreements in the Trump administration. You're not supposed to do that when you employ somebody.
Well, thank you for that. So, I'll just talk quickly about the audit and reporting requirements. And I don't know if there's a quick way to talk about it. I was actually talking to our state auditor, Brian Colon, about this, and he gave me a good example too, where the audit rule is interesting, right? So every government agency in New Mexico that receives or expends public funds is required to account for that money supposedly daily and submit a report to the state auditor annually. So accounting for this money usually takes a form of what's called an audit. And there's a tiered system of certification depending on how much money your entity brings in. However, this can cause really overly burdensome issues for a lot of these smaller entities, right? So how can someone, either an Acequia or land grant, comply with these financial audit requirements? So there's no way that you can read that, but the Office of the Auditor does have a really handy guide to show you whether or not, if you check this box, okay, move to number 2. It's kind of like filling out a tax form, which it seems really simple, but it can be overly cumbersome sometimes. So, although our state auditor did say that they are very willing to help land grants, Acequias, whoever does need help with this, to make sure that they do contact their office. So that's straight from his mouth, so I'm going to hold him to that. There are different tiers, and most will fall into Tier 1 and Tier 2. So Tier 1, if you have less than $10,000 and your public body did not directly expend at least 50% or the remainder of a single capital outlay award, right? So if capital outlay, you receive funds through the state government, through the legislative process, as Representative Lisa explained.
So there's actually quite a few Acequias that qualify under Tier 1 that have less than $10,000 of revenue. So this actually applies, and they have the most relaxed reporting requirements because of how small they are.
Exactly. So then Tier 2, if you have $10,000 or more, but less than $50,000, and I'll go through these pretty quick. And again, these slides are available online as well. Tier 3, less than 50, but if you also have capital outlay as well. And then Tier 4, 50,000 or more, but less than $250,000. And it's interesting because, so there's 7 tiers, but there's really only 6. And again, if you're making over $50,000, and then again over $250,000, and then Tier 7 is the highest tier possible. It's actually not even really a tier because it's literally just a full financial audit that you have to comply with. And then I'll get into the procuring audit and financial review services. I know one of the other presenters kind of talked about this a little bit. When you procure process for an audit or a financial review service, you have to follow what's called the audit rule. And then prior to the beginning of the process for selecting an auditor, CPA, you have to receive written notification from the state auditor authorizing to proceed with selecting an independent public accountant. So it's a really complicated process, and it can be very costly. So it's really important to make sure you do it right the first time, if you will, right? And access the help from the state auditor's office, right? And there might even be some additional funds that you can access through this state auditor's office through like a specific grant. So that might be something that may be available to you. And then I'll just go, I know I'm down to a minute, so the procurement code, just know that there are procurement codes that you do have to follow as a public body, and here are the statutes listed. And then finally, per diem.
And again, on the procurement code, the smaller the job, the less restrictive the requirements are.
That's exactly right. So if we had more time, we could go really into detail, but if you're getting, the limits really started, like if you're hiring somebody to do, say, a engineering of, say, a building or something that you're trying to procure for, and it's over $50,000. Think a lot bigger numbers. So, and just know that, again, I think Arturo mentioned this about, salaries of trustees and records expenditures, knowing that it is available if the grant can afford it, right? So if there's no money to be had, it's not that you have to pay, but it's just that this is the maximum that can be paid. So, but you can make this in your own, bylaw specifically of how much you do or don't want to pay members. So, and the fact that they do and don't have to accept it either. So, and lastly, governance resources. The New Mexico Acequia Association and the Land Grant Council have these great resources printed out. It's available on the website, and as well as the Attorney General, the Auditor, have resource guides. So make sure that you're aware that they're there. They're free resources, and I will leave it at that. I'm going to go ahead and close out. Thank you so much for everyone attending these last 2 days. Thank you to the Cañon de Carnué Land Grant for allowing us to use this space, the Rock Canyon Tap Room, especially to Larry and Leroy for our delicious lunch. Thank you to all of our presenters over the last 2 days. This was a wonderful event. Thank you so much to Lauren Rust, our Utton Center program coordinator. She did a fabulous job making sure everybody had coffee and was fed. Please feel free to take a burrito on your way out, some food. Make sure you take a drink. We don't want it to go to waste. Also, keep an eye out for emails in your inbox. Lauren is going to be sending you emails with a link for all of the presentations. Additionally, if you are an attorney and you need CLE credit, you should have received an email about how to make sure you get credit for attendance. So thank you so much, and everybody have a safe travels back to their destinations. If you don't get an email, give us a call. Oh yes, about the credits. So, and we'll make sure that you